Hello, everybody, and welcome to episode 2 of the Clearly Cloud podcast. I'm your host, Sean Spicer, joined here with your other host, Conrad Agramont. And today, this week's guest is Carey Lening of Knowledgeance. She's a privacy expert who has worked at Palantir and Facebook.
Yeah, one of the things I like about talking with Carey, when we talked with David on the other episode 1, we just start talking about privacy. And I'll tell you, there's so much that's out there. And what I really, look forward to in the discussion with Carey is just really around knowing a little bit more about what these pieces are. And sometimes it feels like a privacy statement. It's just like, it's so boring. But she really gives us some interesting color, especially around like Privacy Shield and Safe Harbor.
Yeah, well, that was one of the things I really liked about the discussion with David last week was when we got into the difficulty of meeting privacy regulations and what it means to be legally compliant globally, because there's no borders in the cloud. And that really kind of hung with me the last week. I've been thinking a lot about that. And one of the people she talks about was this Max Schrems guy. So Schrems 2 was the case that kind of killed Privacy Shield. How do you feel about trying to get him as a guest, Conrad?
It would be very interesting. It might be pretty cool. I mean, when I first heard of Shreb 1 and Shreb 2, I was like, what is this? Because I know it's over in the EU. I was like, is this some kind of acronym or standard? I didn't know there was Maximilian Shreb. So it was pretty cool to learn. Yeah,
and Carey talks a little bit about that today. I'm pretty excited to get there. But there's been a lot going on this week. I thought this week was going to be kind of slow after the House hearings the week before with Google, Apple, Facebook, those guys. So why don't we just jump into the news? Because there was a lot going on.
Let's do it.
5, 4, 3, 2, bringing you some news.
So as I said, I thought it was going to be a slower news week after everything happening with the House hearings last week. But of course, it is DEF CON this week. So I was expecting a lot of news about breaches, and there really wasn't that much out of Black Hat. However, on the subject of security, the FBI announced that Windows 7 might be a security risk.
The whole operating system might be a security risk?
Yeah.
Like the green background, like the whole thing.
Look at my comment on this, man. And other news, Earth is round, water is wet. There was also a study this week that said masks are more effective if you wear them over your nose. And people get paid for this.
Did you just put the whole mask over your nose or mouth and nose?
Mouth and nose. But I mean, really, where are all the exploits? This is Black Hat week. Usually Black Hat, like there's crazy stories about like, oh, you can deliver malware into secure environments using a pacemaker. Like they're going to hack your eyeball. And the biggest news this week seems to be that a voting machine tech company, Election Systems and Hardware, formally announced a vulnerability disclosure policy. The reason why that's news is because they're the first ones. Like, it's 2020. How is this the first company, first voting machine company to have a vulnerability disclosure policy?
So I want to go back to you're saying pacemakers can be hacked. Is it that pacemakers are doing the hacking or they can be hacked?
It's usually Black Hat has got these really obscure hacks.
I just didn't know if maybe there was a consortium of heart attack people that created these, hacking device for their pacemaker that it was just like could you see a whole bunch of old people being hackers? It could be a new trend.
Well, the big focus last year was IoT and healthcare because it was insecure. And that's the big thing around Windows 7 as well, is that hospitals and grocery stores, we're both the last to come off of XP because they have these embedded systems. So, yeah, are you going to upgrade Windows 10 in a sonogram or ultrasound machine?
Oh, I'm sorry. I can't get this thought out of my head or this picture in my head. They always talk about like hackers are really just these kids who never left the house that are sitting in their parents' basement. Can you imagine that particular person who was trying to hack a pacemaker? I mean, they're trying to kill their parents.
Well, that's because they won't let him out of the basement.
Dad, his dad's like, son, stop it. I think I got it, Dad. I'm ethical hacking. Oh, my God.
Right. Well, also, speaking of 17-year-old boys in their basements, so a 17-year-old Florida boy, so a Florida man in training, was arrested for that Twitter hack, which fizzed credentials including Apple, Jeff Bezos, Bill Gates, Kanye West, like a whole bunch of really high-tier accounts to run a Bitcoin scam, and made $100,000 in one day. So cops arrested him, and his hearing was this week. And at the hearing, they had to hold it over Zoom because of COVID-19. They got Zoom bombed, and somebody started playing porn. Probably another 17-year-old Florida boy.
Was it the same guy in there? He's like, he set it all up. He's like, I'm that good.
When Kevin Mitnick, who I'm hoping to get on the podcast, when he got put in jail, he wasn't allowed to use a payphone, and they were worried that he would be able to launch nuclear warheads from a payphone. We've come a long way.
Do you want to play a game?
Yep.
Some things just don't go away. I mean, it's, hacking at its finest from way back in the 80s.
Yep. And I mean, I guess the big news of the week is that TikTok is going to be banned on September 20th.
TikTok, I mean, that's only going to be helpful for me with my kids, but no, they don't really do a lot of TikTok. But that is interesting. I mean, is there like is in that executive order, was there like an out clause, like unless Microsoft buys them?
So there have been talks about it, but I think it's so convoluted now because Satya Nadella got on the phone with Donald Trump, and then Donald Trump started making demands about the U.S. government should get some money from the proceeds of this deal. And now there's we're in this completely weird gray area because, well, how does that work? That the government's not supposed to be involved in private business like that. So it's interesting. So I don't know that deal is going to go through. We'll see. But that was kind of a drop dead date for them even before the executive order was passed. But what's interesting is the executive order goes after ByteDance, which is the parent company of TikTok, as well as WeChat and their parent company, Tencent. And once I heard Tencent, I'm like, oh, wait, that's Fortnite. And so they are the parent company of Epic Games and Riot Games. Riot Games makes League of Legends, one of the biggest online esports games around. And this forced the White House to come out and go, no, we are not going to ban Fortnite. But WeChat's problematic because it's more of a hub software. So the first time I heard about it, they were using it to buy real estate here in the U.S. It's a payment system. It's used for dating. It's going to be curious to see what the impacts are of that kind of long term. But there was also some stuff in the news about TikTok facing potential problems in the EU after Schrems 2, which we're going to be discussing today with our guest.
Cool.
So let's move on to guests.
4, 3, 2, 1, having some fun with guests.
All right. This week's guest on the Clearly Cloud podcast is Carey Lening from Knowledgeance. How are you doing today, Carey?
I am excellent. How are you guys doing?
Doing very well, thank you. So why don't you start by telling us a little bit about yourself?
My background is actually in law and in computer privacy, data protection, and cybersecurity. So I have this weird intermix between being able to talk like a lawyer and also understand tech. So that makes me kind of maybe the bane of existence for engineers everywhere, or, makes them happy, drives my engineer husband crazy. But yeah, I was a practicing lawyer for a number of years out of Washington, D.C. And then I decided that and I was working on data protection issues and helping companies with that sort of a thing. But I decided that I didn't really want to do that. I wanted to get more into the technical side of stuff and go into cybersecurity. So I picked up shop. I moved back to California, which is where I was born. And I took a gig at Palantir Technologies, the shadowy organization that is now soon to be filing an IPO. And so once I was at Palantir for a couple of years and was doing, again, a juxtaposition of a little bit of tech and law issues, dealing with policy stuff for them, dealing with research stuff for them. And then when I left Palantir in 2014, I took a job with a security firm in the Bay Area and was there for a number of years. And then I worked for another couple security firms. And then I decided to open my own thing. And so I opened a consultancy in California, also in the Bay Area, and handled lots of client issues around what was fast becoming the GDPR, or fast becoming the implementation of the GDPR, I should say, and helping folks with these new novel concepts like setting up records of processing activities and explaining what a data protection impact assessment was, and helping firms actually like make sense of this, because the General Data Protection Regulation, which went into force in 2018, was really new for a lot of the U.S. folks. And I'll talk a little bit more about that, in follow up.
Yeah, I love how you brought up that your husband, who's an engineer, drives him crazy. He must come with some like exciting things, like, I just did these things. They're like, oh, that sounds great. So how do you manage the privacy on that? Like, again.
It's actually more annoying than that. So the thing, I joke with people that the thing that I learned in law school was not the law. The thing I learned in law school was how to think in metaphor and how to think in analogies. And to understand that nuance is everywhere. And so there's very few things in law that are black or white, right? But in engineering, it's all binary. Well, it's not all binary, but it's frequently binary. And so sometimes I will have a very long-winded answer to a question of his that is full of analogies and these yeah buts, and it drives him a little nuts. He's just like, just answer my question, yes or no. And I'm like, it's not that simple. So fun.
It's interesting that you mentioned Palantir, because when you think about privacy, Palantir is not really the top of that mountain.
Right.
Palantir, you said, is a shadowy organization. Did that contribute to your interest in data privacy?
Yeah, so that's a really interesting thing. So I should back up and say, when I moved out to Ireland, and then I went and worked for Facebook, so I can explain both of these things actually. So let's talk about Palantir first. So when I first signed on with Palantir, they were still relatively new. And most of the thing that attracted me was actually the work that they were doing, primarily for the private sector and for like NGOs. So if you remember way back in the day, the stuff that they did with the government was like very kind of good. It was the finding IEDs in Afghanistan, or helping, military personnel, detect where terrorists might be to avoid, getting shot at. And so these were like kind of good soul affirming things. And the other stuff that they were doing, like when I was early on there, there was a monsoon typhoon in the Philippines. And it was, they used the Palantir technology to help people who were on the ground actually facilitate, communications between healthcare providers and people who were stranded or who hadn't received services. So the Palantir tool itself is actually kind of can be used for very, very good purposes. And so early on, they were doing it for like bank fraud and trying to stop people from doing really nefarious stuff. And so when I went and applied, I actually had a conversation with one of the founders. We sat in and had like an hour-long conversation. I said, look, I have serious reservations about this company because I know that the tool is powerful and I know that it can be used for ill purpose. I want to know that you guys have some assurances and some safeguards as to how you're using it. And so we talked about, there was a privacy and civil liberties group at the company who for a long time actually had a lot of clout. And there was a lot of assurances and safeguards that were built into the sales and business practices where they weren't going to be doing the kind of nefarious, sorry, Sean, but the nefarious shit that they're doing now.
Yes, the first one.
Yeah, sorry. When I was there, it was just a slightly different Palantir. And when I got out, it was because their policies and their positions had begun to shift. And so they weren't working with the NGOs. They weren't doing humanitarian stuff. They were working with questionable private sector companies or questionable to be private sector companies. And they started doing a lot more stuff with government. And so I just said, that's not for me no more, guys. They weren't listening to a couple of their great people that were on the PCL team who were trying to work with them and trying to build in what's called privacy by design in privacy land. In other words, building in privacy preserving and privacy protecting features into software before it gets launched. And I did the same thing. My goal when I moved to Ireland and took a job with Facebook was actually similar. Again, I had this very naive notion that Facebook, the company that we all know and maybe hate, could actually be better. So this was after Cambridge Analytica came out, around the time Cambridge Analytica came out. There was a big push by Mark Zuckerberg and senior leadership to put in some privacy controls, to really kind of change things and institute things like data minimization and anonymization and pseudonymization.
I was just going to bring it. It's interesting that when you bring that up, I worked at Microsoft for many years, and I remember, it was in 2000. I'm going to get the day wrong, like 2003, something like that. There's this huge problem that happened with Microsoft SQL Server where it became easily hacked into. And so the company actually shut down for 2 weeks. By shutdown means, nobody was building new code. Everybody had to review other code. I was actually asked to go in and do code reviews with the other teams and make suggestions. And we'd all do security training. But it's kind of typical, right? Like even years later, even I bet now that you feel like, well, I've done a okay job of security. It isn't until somebody completely embarrasses you that everybody says, okay, well, we are a multi-billion-dollar company. I guess we should put a greater focus on this. And it happens again and again and again. But, with GDPR and some of the other legislation that goes out that has this higher amount of risk of penalty, it's, I think, motivating more people, but there's still so much more to do.
Oh, yeah. And with GDPR in particular, that just smacked companies like Facebook upside the head because there was, it was not like GDPR is new. This is very well grounded in history, but GDPR actually had teeth or has teeth. Mm-hmm. And so that makes a huge difference. And so when I was at Facebook, I was trying to help them actually meet their GDPR expectations and obligations. And so I worked directly with their data protection officer. I worked directly with their privacy legal teams. It was an exciting ride.
Well, you really stepped into a perfect storm. So you went into Facebook right after Cambridge Analytica. Then you moved to Dublin, and Dublin is this just data haven in the EU.
Yeah.
And then there's GDPR. And then the Max Schrems cases start. And so you were really right through the middle of all of this. Oh.
Yeah. So to Dublin first, actually, my husband and I moved in end of 2017, right at the beginning of 2018, where things started kicking off. And of course, GDPR went into force in May 25th. So nobody had their stuff together. Nobody, was ready to go, and Facebook was no exception. And I think they would be honest and admit that because people were flying blind, and in some cases they're still flying.
So, and it's still a bit of a storm out there, tumultuous, if you will. That 2 weeks ago, the Privacy Shield was struck down. And that's actually what got you and I talking, was like, what's going on? So I always say I've got an expert for everything, and Carey is my expert for privacy. So
Expert is very generous, by the way. So July 16th, the European Court of Justice, who heard a case many, many moons ago, issued a ruling that the current framework for data transfers, cross-border data transfers under the GDPR was kind of warped. Namely, that the U.S. Privacy Shield was not something that would work because it was inadequate. In other words, it didn't meet the strict levels that are in place from the GDPR. Okay, so they also issued some other bits and pieces, and I'll talk a little bit about that. But I think the first thing that's worth talking about is what the hell is adequacy? So adequacy is this idea under the GDPR, actually predated the GDPR, which lays out a number of, kind of obligations. The main way to think about it is the GDPR says, hey, look, if you are a controller or processor of data, in other words, if you're the owner of the data or working on behalf of someone and doing things with that data, personal data, and that data involves personal data of people in the European Union. So that's EU residents, not necessarily citizens. It's things like fairness, making sure that, you're processing for a legitimate, legal reason, that you're transparent about why you're processing and what you're doing with that data, who you're sharing it with. That if you're relying on user consent, you're getting that consent in an informed, explicit, and fully knowledgeable way. And that there is adequacy when you're transferring data outside of the EU. When it comes to transferring, the GDPR has a number of rules between what's called a data exporter, that's the EU side, and a data importer, or a company in a country that is not in the EU. And their goal is to provide an assurance to data subjects that the provisions that are in place in that other country are adequate to the GDPR, right? Mm-hmm. So sometimes there's formal adequacy decisions that are reached between the various governments. So right now, a number of countries like New Zealand and Japan have formally recognized adequacy decisions. So the EU says, all right, you guys are cool. You're sort of like the EU, but your privacy is like the EU. So we're good. But the problem is that it's really slow and it takes a long time. And so there's only like 6 countries that have adequacy right now. And the United States is not one of them. So that leaves a big problem, which is, what does everyone else do in the interim? Like, how do people want to keep transferring information, particularly to the United States, because that's where all the big boys are playing. So we got to have some other mechanism for that. And so the GDPR has envisioned a number of different means that a data exporter can work with dealing with cross-border transfers. One of those is this idea of standard contractual clauses, and I'll talk a little bit about that in a minute, or binding corporate rules, which are similar. And then the other is the U.S. Privacy Shield. That's what the Schrems case was focused on. And so Schrems was brought by a guy named Max Schrems, who's got a bit of a history here. He's Austrian, and he filed a complaint in 2018 with the Data Protection Commissioner in Ireland, challenging Facebook's standard contractual clauses. So Facebook actually was not a U.S. Privacy Shield participant, which is interesting. The U.S. Privacy Shield, I'll back up, was a mechanism in place that was basically self-funding. It said that, if you're a company and you pinky swear and agree that you're doing all of these right things that are designed to be privacy preserving, then you're good to be, and therefore, you have adequacy. And it was all done on the US side. And a lot of the data protection authorities across the member states in the United Kingdom kind of winked and nodded and said, yeah, okay, fine, that works.
And so Privacy Shield came out of Safe Harbor, correct?
Sort of. So let me give the Schrems backstory here, and then I'll explain it. But yes, you're right. So as I mentioned, Schrems brought this case in 2018 in Ireland, and he's got a bit of a history. So in 2013, he brought a previous case also against Facebook and the Data Protection Commissioner in Ireland on similar grounds. But he was challenging what was then in place, which was the U.S. Safe Harbor. And the U.S. Safe Harbor was, again, very similar, like what you said, Sean, to the Privacy Shield, equally a self-certifying kind of pinky swear kind of a arrangement that companies could sign on to. And in 2015, the European Court of Justice ruled that, that didn't make adequacy. That wasn't sufficient. And so they invalidated that. And so the U.S. went back to the drawing board, and then they came up with Privacy Shield.
There's got to be something cool about knowing that when they bring up your name in cases that they just refer to your last name and give you a 1 and a 2. Schrems 1, Schrems 2, like that's me.
Yeah, he's an interesting character. He's actually a lawyer, and but I think when he originally filed the suit, he was just in law school.
I mean, it is interesting, like with Schrems 1 and 2, is that you kind of you like that there's somebody out there agitating this part on your behalf, because a lot of people just feel like, well, I'm just a consumer and I'm just using these things, and like, oh, it's just businesses, but these businesses hold my data, and so you kind of regret that somebody is nudging that system along some way.
Right.
Exactly. Yeah.
And a lot of this was inspired and kind of stirred up prior to that with Snowden and the revelations around PRISM.
Right. It's not just businesses, but and that's actually what both cases kind of center around, is this idea that what Schrems was really complaining about was not just that Facebook was transferring data, but it's that Facebook was transferring data to the United States. Mm-hmm. And he said, hey, look, it doesn't matter what provisions are in place. The United States just surveils like crazy. And so you have FISA 702, and you have these executive orders that give the intel authorities a tremendous amount of privilege to go in and just suck up data. And so Snowden, talked about PRISM and talked about a lot of the, just huge data sucking enterprises. And the fact there's very little oversight of these things is a huge problem. And then I know you guys talked with David before, and he talked about the Cloud Act, and the Cloud Act is very similar. There's just, again, more opportunity for this kind of extraterritorial reach by the U.S. government. And that is deeply concerning to the EU. And it's deeply concerning to, rights holders and to data subjects and to data authorities. And so that's why these cases are brought about for. So what's interesting is Schrems 1 got decided, validated U.S. Safe Harbor. And then he brought a suit in 2016, like literally the day of the GDPR going into force, challenging the same folks, again, for the same reasons, but this time, under the GDPR, because that previous decision in Schrems 1 was predating the GDPR. It was following an earlier rule called the Data Protection Directive. Ireland gets this case again, and they're like, well, crap. All right, so we got to deal with this again. And they just punt. They basically say, okay, we went through this song and dance before. We got the wrong decision the first time. High Court, you tell us what to do. High Court says, okay, well, I don't know. And they punt it up to the EU Court of Justice. That's like the Supreme Court for the EU. That's where things are. That's where the things were prior to July 16th. One thing that I should do before I talk about the ruling is talk a little bit more about what a standard contractual clause is, because what ultimately Schrems was challenging was actually not Privacy Shield. He was actually focused on the standard contractual clauses because that's what Facebook was using. Remember, I said they didn't sign on to Privacy Shield. I think companies like Google and a few others did. A number of companies actually did, but Facebook decided to go their own way and go with standard contractual clauses. So what are those? So those are a set of basically contractual clauses or agreements that were created by the European Commission in 2010. So again, predating the GDPR, excuse me. They outline a set of specific obligations and guarantees that data exporters, so folks exporting data outside of the EU to non-EU data exporters, have to abide by. And it's a number of stuff. It basically kind of mirrors a lot of what's in the GDPR because, again, the GDPR came from the Data Protection Directive, and the Data Protection Directive was enforced. And so some of those things are like requirements that the data importer provides adequate technical and organizational security measures. The data subjects are adequately informed of the transfer's purpose and terms. That there be a legitimate reason or a legal lawful basis for those transfers, and importantly, that there's assurances that processing is done only on behalf of the data exporter. So what that means in practice is that the data exporter is kind of assuring that there are no laws that will supersede the rights of the data subject.
I got it. So if is the standard contractual clauses, is it kind of like a regulation, like hey, you have to follow these rules, or is it that there is that kind of standard language in the contract that two parties have to then agree to that attaches to the EU? Like, is there some additional paperwork? It's like, no, it's just a thing we have to do.
It's the latter. In fact, actually, you've probably seen them. Like, to deal with, and you worked for. You were at Microsoft in maybe a little bit before all of this, but if you've ever signed an agreement where you've taken data from an EU company or, data about EU subjects, there's this annex usually that gets tacked on as like, Annex A or, something like that. And it's this boilerplate set of standard contractual clauses. And it kind of it sets out all the rules and obligations that both parties need to abide by.
Okay.
And most people ignore it because it's almost like when you're buying a house, you have this like set of, boilerplate legal things that you have to do to talk about how you have like asbestos everywhere in the house and you understand that and you're not, if you have lead paint, disclose that sort of thing. It's the same kind of idea. And
it reminds me of here in the U.S. with FARs and DFARs is that every contract with the government has to have these X amount of clauses that say, yes, we're going to do security this way. Yes, we're going to make sure that we comply to ITAR if necessary. So it's just every contract has to have it. It's the EULA.
Right.
It's the EULA. Yeah. It's the EULA. And most people honestly just kind of winked and nodded and said, yeah, cool. These standard contractual clauses. And of course they didn't read them. And so that's kind of how things were for forever, at least prior to the Schrems II decision. As I said before, Ireland punted. High Court said, we don't know either. So they sent it up to the European Court of Justice. And along that route, actually, a few additional questions got added to the mix, including whether or not Privacy Shield was a viable option, and then also obligations of the data protection authorities or supervisory authorities generally when it comes to prohibiting or suspending existing transfer agreements. And that latter bit will be important a little bit later. So what the court found was that while these standard contractual clauses in principle are still valid, it imposed a number of obligations on data exporters and data protection authorities going forward. So the court stated that exporters are now under an affirmative duty to assess the law of the country that they're importing data into. And as I mentioned before, that was already the case, right? If you actually read the standard contractual clauses that nobody reads, it actually says that, as a data exporter, you need to be aware of the prevailing legal landscape in the country you're planning on doing a transfer to, because if that legal regime doesn't allow the protection or adequate protection of data subject rights, you can't do that transfer. But again, nobody was really doing that. And so this decision basically says, you really got to do that. And so now everyone, now all these companies have to basically become kind of legal analysts or hire legal analysts to look at the law of these different jurisdictions to say, all right, is this going to run afoul of the GDPR or not? It also kind of requires that a data importing country provide information to a data exporter the moment that the laws change and a surveillance state kind of situation happens. This is for all countries. This isn't just the United States. This is basically saying you're transferring data to any non-EU or EEA country or any inadequate country that hasn't been deemed adequate. You need to look at all of this stuff. So that means China, that means India, that means United States, Mexico, any number of places. So it's pretty substantial.
Yeah, I mean, that kind of sets up kind of the next part of this all, right, is that you have these different regulations and some, we talked about with, they have these contractual, additives put in there that you have to meet. And now it's like, okay, it goes away. I mean, it's the thing, like some of these policies take years to put together and then it can fall, crumble, change, adjust. And like you said, then it gets multiplied by the countries that you work with. But then now once you have all that in place, which is a constant moving target, which is weird because you normally think laws go in and it's like that forever. But they're always changing in every other place. So it makes it, they're always moving. But now that you got to handle the effect of it, like what happens if there is a breach? What happens if, there is not so much a breach, but somebody takes some action against me? And then you got to look at, kind of the next part of how to handle that and, an enforcement. Right.
And I think what's troubling particularly about the U.S. laws is that they're so broad and so encompassing that it really does apply not just to the big boys like Facebook and Google and Amazon and such, but also the small startups. Like anybody who's grabbing data can potentially be targeted by various rules under the Stored Communications Act or by various rules like the ECPA or the Cloud Act or any of these things. They may not be having a FISA warrant thrown at them, but at the same time, the U.S. laws are massive, and the surveillance state in the United States is huge. And again, the same thing goes for China or India or Russia or any of these other places where people could potentially be sharing data with a country whose surveillance arm is large and vast. So it really, really does throw a wrench into a lot of things because it would be very challenging for any company in the United States, I think in most cases, to assert that they have standard contractual clauses that they can abide by that will overcome the U.S. surveillance laws. I'm not saying it's impossible, but I guarantee you Amazon can't, Google can't, LinkedIn, any of those companies that have EU data, they can't. And they can't, in good faith, sign on to these standard contractual clauses promising that they could do it when they can't meet that promise.
Right. And if it weren't for GDPR, then there wouldn't be teeth in order to make them even care if they can meet it or not.
Right.
So once you contractually agree, then you have to do it because GDPR can come in and can actually have some really high penalties.
Right. Between 2 and 4% of worldwide turnover for the most egregious fines, although no one's really hitting that mark yet. There have definitely been some fines, but the 2 fines that are the largest, one against British Airways and one against Marriott, and we'll talk a little bit about that in a bit. The fines have not been actually imposed yet. It's a bit of a joke. Sigh. Anyway, yeah.
And then GDPR also has teeth if you not just sharing with the government, but that the data breaches.
Yeah, exactly. Data breaches and all sorts of violations that are really kind of fascinating if you start looking into the information. So go ahead. Let me go back and finish the Schrems decision, and then we can kind of jump because I want to finish the thought so it doesn't derail too much. So the other thing that the Schrems decision decided, in addition to invalidating Privacy Shield as inadequate and putting all these, rules around standard contractual clauses, is that it also requires DPAs to basically step up their game and actually start policing these transfers, which means potentially blocking or suspending transfers anytime a data importer can't meet those obligations.
And the DPA is a data protection authority, right?
Yes, correct. Right. Sorry, I need to stop using all the acronyms. And so my home data protection authority is in Ireland, and that's Helen Dixon, who is the Data Protection Commissioner of Ireland. But this is true for all DPAs in all the European Union states. So, yeah, it's going to be a lot of work for them. It's going to be a lot of work for the different companies sharing data and transferring data. It's just it's a really, really big decision. They invalidated Privacy Shield. And they specifically called out the U.S. surveillance state as one of the main reasons, because they found that in all of the various rules, a data subject really had no rights, particularly a non-U.S. data subject really had no rights for any kind of judicial recourse or review. And so it just, there was that violates a whole ton of GDPR requirements and provisions. So it's going to have knock-on effects for some of the other mechanisms for data transfers, including binding corporate rules, which I talked about, and for any kind of cross-border transactions with countries like China or with the UK once Brexit is completely done after December 31st of this year. So the UK is not an adequate regime. They have not had an adequacy determination, and now that they're leaving the EU, they basically have to. And they're going to have it's a huge mess. And they're going to have one hell of a time because they recently signed on. They're the first country that signed on, with agreement under the Cloud Act. And that is not, the UK was already a bit of a hot mess for its own surveillance state aspects. But signing on to the U.S. with the Cloud Act is just not going to do it any favors, and so they're going to have a time. So it's going to be a very interesting next few months / years watching all of this play out in the courts. They didn't totally screw everybody. They said that, again, standard contractual clauses are valid in principle. And even in the context of like the United States or another country that would be where standard contractual clauses by themselves wouldn't apply, there might be a way around this if the data exporter and data importer adopt certain additional safeguards and, quote, supplementary measures. The court was light on details on what the heck those actually are. And all they said was that it was something that would be assessed by the data protection authorities on a case-by-case basis. But some of the folks that are far smarter than me are kind of hypothesizing that this means things like you need unique identifiers whose keys are not shared with the data importer, read-only access where copies or printing is impossible, like on thin clients, or implementation of strict data storage limitation provisions like delete upon read. So it's not that data transfers will be impossible. It's just going to be something where I think more technical controls will have to be in place before you're legally able to be transferred, to transfer things to the United States again.
Wow.
Yeah.
But because it's on a case-by-case basis, we really don't know what is going to come out of that.
Right. And it's going to be a lot of things in front of various regulators and a lot of people playing fast and loose and hoping that they don't get caught, I think is actually what the reality is. And one of the ways that they can actually play fast and loose is by looking at there's one other mechanism for transfers. This idea of derogations. Derogations are just a fancy word for exceptions. I don't know why they don't just say exceptions to the GDPR. But a derogation basically says, look, here's some carve-outs that, we recognize probably need to exist. A really common one that a lot of people are familiar with is obtaining a data subject's specific, informed, and explicit consent. And people shorten it to consent, but it's really important, those first three terms, specific, informed, and explicit. It can't just be opt-in, it can't just be opt-out. It has to be opt-in, and it has to be detailed enough to explain what the terms of the transfer are. Otherwise, it's not considered sufficient consent under the GDPR. Companies can also transfer data to inadequate regimes if they are trying to perform a contract between the controller or the data exporter, for instance, and the data subject. So not between the data exporter and the data importer. That's not allowed. But if they're doing something on behalf of the data subject and there's a contract in place, that can work. To meet the vital interests of a data subject that can't consent. And that's really, really narrow. Think like health information, or for the defense of EU-based legal claims, or for other compelling legitimate interests of the controller. And that looks like a very big, broad carve-out because any company can say, well, I have this legitimate interest, and that is to make money. And the thing is that is not a legitimate interest as far as the GDPR is concerned. So that's another one of those case-by-case basis kind of deals where a potential data exporter is going to have to come in front of their supervisory authority and say, hey guys, I have a legitimate interest in transferring this data to Amazon, for instance, or Azure. And here's what it is. And then the regulator is going to have to say, well, maybe, okay. And they're going to look at a few things. They're going to say, what is the purpose? What is your legitimate lawful basis for using this data? How much data are we talking about? How long? What's the scope? How is this going to impact the data subject? Because a legitimate interest determination is something that balances the rights of the data subject against the interests of the data exporter, the controller of the data. And so it's really a balancing test. It's really going to be something that needs analysis.
So what happens if somebody is in violation? I mean, how many instances?
Okay. So I have been, as a little bit of a side project, looking at the nature of how the authorities are actually dealing with GDPR violations. So a little bit of background research here first. since the 25th of May in 2018, regulators have received about 225,000 complaints under the GDPR for various violations.
Wow.
There's a lot of, it's a lot. And there's a lot of different things. So things like access requests. If I'm a data subject and I want to have access to all the information that Facebook has and Facebook punts and doesn't respond, that would be a violation of my access rights. And so I could file a complaint with the regulator. But it also includes things like data breaches. And I was particularly interested in the data breach aspects. So of all actions, of all enforcement actions that have made it to a final stage, there have only been about 361 complaints that have had a formal, enforcement action, penalty / notice, whatever. And that's across all of the GDPR possible complaints. Within the data breach universe, there have only been 89 actions that have had an enforcement or a penalization kind of ruling. And so it's like 0.005% of all of the data breaches that have been reported to the various data protection authorities. So because the GDPR requires that you report a data breach, any kind of data breach that affects personal data, unless the breach isn't likely to affect a data subject's rights. And the only cases I can think of is like if someone grabbed IP addresses, like if it was just a database of IP addresses and nothing else, like a unique identifier and IP addresses. Yeah, that's technically considered personal data of a data subject, but by itself is probably not going to be something that would rise to the level of having to report a data breach. But anyway, these obligations require that controllers and processors inform their respective data protection authority within 72 hours anytime that there's a data breach. So that meant that there's been about 161,000 cases that have been filed with regulatory authorities.
Why have there been so few actions taken? I mean, GDPR's got teeth, but it's not taking any bites.
Regulators are limited. The budgets are tight, especially after COVID. And DPAs often have small staffs. The authorities have small staffs. In some cases, like Ireland, the data protection commissioner has 30 people who are working legal / kind of regulatory capacity, because I looked on their org chart, and they've only brought 5 cases. They've only had 5 enforcement actions, and they get the vast majority of cases filed against them. So I think some of it is due to staffing and money, but a lot of it is just due to reluctance. It's really disappointing as a data subject to see that Ireland isn't really doing anything, because I'm like, nothing changes that way. Nothing gets better. And I think that, I don't want to disparage Helen Dixon, who's the data protection commissioner, but I think that there's a reluctance on her part to go after these companies, because Ireland's status as Ireland's economy in a large respect is based on being kind of the EU data epicenter for a lot of U.S. multinationals. They're tax advantaged here, and the regulatory climate is very good. And also, there's a regulator that just doesn't really try to enforce as much as, say, like Germany or Spain or France or any of these other countries.
Yeah, and you do hear about all the tech multinationals being in Ireland. You don't hear about them being in Germany. What you hear about in Germany is that they have a sovereign cloud for just Germany.
Right. And that's because the German regulators are actually robust and they actually go after people. And so Germany tends to find, on the heavier side, they find, in the millions. Most of the heavy hitter regulators actually are only finding, sub 100,000 euro.
What do you think the differences are between EU and US privacy concerns, and why there's this mismatch?
Right. So if you do, I had to go through constitutional law in law school, and what you realize is that privacy is not actually articulated anywhere in the Constitution. It was born out of a judicial set of decisions based on rights in the 4th and 14th Amendments. And the rights in the 4th Amendment in particular are all based on, your right to security in your persons and effects. And all of that is really around property. Your papers and personal effects are property.
Mm-hmm.
And so the U.S. system is always grounded in privacy as a property right, or privacy as a kind of a right that is ultimately sellable. And so, there's moneyed interests that convince Congress every year that, this sellable aspect is really important. And, that keeps a lot of privacy legislation out. You're getting some changes at the state level, California being the most notable with the California Consumer Privacy Act. Yeah.
And then, so where is privacy in the UK centered? Is it the same kind of property right, or?
Well, when the UK was part of the EU, they were grounded under the idea of the European Human Rights Convention, the ECHR. And so they had to abide by all of that. And the ECHR is grounded in the idea of human rights, of rights as an individual that you get from birth. It has nothing to do with property. It's just like, the right to be, safe, and the right to have freedom of movement. These are all human rights. And so privacy was in the data protection and privacy in the EU is grounded from that basis. And so it's much more fundamental, much more, I don't even know what the word for it is, but, much more solid, I think, than the property argument that has been developed in the US. And so that's why the rights are a bit stronger. And the UK, recently had, signed on to that. Now, what's going to be interesting for the UK is I think ultimately they kind of fall back in line with, obviously the US legal system is based on the UK legal system, right? And so, a lot of these things, I think the UK will revert more to the way that the US is looking at privacy. And I think that's what's going to make it really hard for the UK to demonstrate adequacy for the same reasons that the US will have a hard time demonstrating adequacy.
Well, we certainly have a lot to figure out regarding privacy as we grow into this global cloud, because as we've talked about in a previous episode, the cloud has no borders. And as we deal with the borders and I think we do have to come down to a foundational idea of human rights, privacy rights, and really what is data. And Carey, you and I have been playing around on the internet long enough that we remember some of the First Amendment fights that occurred in the US where it's, that's not papers, that's data. It says papers. Yeah. So it has been really interesting to watch. And it looks like there's a long way to go with everything in the EU, particularly with the US and now with the UK with Brexit. I think this is going to be a very fascinating place to watch. So how can people reach you, Carey? If they're looking for an expert.
So I'm on LinkedIn, and I'm under Privacat. So Privacat. I am a unabashed cat lover. Also on Twitter under the same nom de internet, so Privacat. And then I have Knowledgeance has a website. It's at knowledgeance.info. So, because .com has been owned by some dude who I haven't seen anything happen with for like a decade.
I felt that way with SeanSpicer.com. All right. Well, thank you so much, Carey, for joining us today.
Holy smokes, here comes some really bad tech jokes.
Conrad, tell me a joke. Be funny.
Sean, I don't know if you had this, but all of a sudden my computer started belting out someone like you. It's Adele.
Oh, I was going to ask if it blue screened.
No, it's just Adele.
All right, so I've got one for you, Conrad.
All right.
If a boy can't post about his girl and a girl can't post about her boy, what does that mean?
I don't know.
They're not supposed to be together.
Okay.
I mean, I guess that kind of fits in with the whole TikTok thing. And
Very topical. Very
Yep,
topical.
that's it. I try to keep up with the news, but that one popped up on my feed this morning, and I just told my friend, I'm like, I'm stealing that for the podcast this week.
That was wonderfully terrible. I approve.
All right. Well, that brings us to the end of the second episode of the Clearly Cloud podcast. Be sure to tune in next week, where we will have James Benham of JB Knowledge, who's one of the foremost experts in construction technology and a true futurist.
Somewhere out in cyberspace, there